Under the common law assumption of risk doctrine, people who voluntarily participate in an inherently dangerous activity, such as skiing, are deemed to have assumed the risk of dangers inherent in that activity, and therefore are liable for their own injuries. In the 1991 case of Clover versus Snowbird Ski Resort, the Utah Supreme Court considered whether a ski resort could be liable for failing to exercise ordinary care and eliminate a known and unnecessary risk to a skier. On December 5, 1985, Margaret Clover was a patron at the Snowbird Ski Resort in Utah. On the same day, Zullinger and Barney Norman, who were chefs at the Plaza Restaurant at Snowbird, decided to go skiing at the resort before work. On their final run before heading down the mountain for work, Zullinger decided to take a jump off a crest on the side of an intermediate run that he'd taken many times before. The crest allowed a skier to catch air because of the steep drop-off on the other side. However, due to the steepness, it was impossible for skiers above the crest to see skiers below the crest. Snowbird's management knew about the crest, and the Snowbird Ski Patrol often instructed people not to jump off it. Further, there was a sign instructing skiers to ski slowly at this point in the run. At the time, Clover had just entered the ski run from below the crest and had stopped or was traveling slowly. When Zullinger landed, he collided with Clover, severely injuring her. Subsequently, Clover sued Snowbird and Zullinger in state district court based on negligence. Specifically, Clover argued that Snowbird was liable for her injuries because it negligently designed and maintained its ski runs. At the time, Utah had an inherent risk of skiing statute that barred suits against ski operators for injuries caused by an inherent risk of skiing. After Zullinger settled with Clover, Snowbird moved for summary judgment, arguing that it couldn't be held liable for Clover's injuries under the statute. The court agreed and granted the motion, concluding that regardless of a ski resort's culpability, it couldn't be liable for an injury resulting from one of the inherent dangers in skiing. Clover appealed to the Utah Supreme Court.